And I want you to think back to the era of the late 1980s. And this is a kind of a sad chapter in the history of municipal court in the sense that in many circles, municipal courts were not necessarily regarded, but were certainly treated as the red-headed stepchild of the judiciary. Marty, I remember from your era, you remember those days. They're very unhappy days. I think things started to change a little bit when Robert Wilentz became our Chief Justice, and one of his goals was to increase the professionalism of the municipal courts. And over the ensuing decades, there's been enormous progress made toward that end. But the beginning of our story is at a time when, certainly not as a matter of policy, but just as a matter of practicality, the municipal courts were not considered on the same par from a professionalism standpoint as were the Superior Court. Now, this played itself out in the Rules of Court in the sense that the Rules of Court depended in Part 7, which are the municipal court rules, very heavily on the criminal rules in Part 3. And there are quite a number of cross-references between the two of them. And I think it's really a factor that municipal court practice was not taken seriously enough, the matters being regarded as so minor that any procedural defects that were necessary in municipal court practice could just be borrowed from the criminal practice as set forth in the Part 3 rules. So there were quite a number of cross-reference provisions in the Part 7 rules, always pointing to Part 3. And it made for some uncomfortable interpretation of the rules sometimes because, as we all know, just as being practitioners, municipal court practice in many regards is unique, and what happens in Superior Court has nothing to do with the realities of what occurs in the municipal court context. So this kind of came to a head in a case called State versus Gonzalez, a matter that went before the law division in Burlington County on a municipal appeal. Judge Haynes, Martin Haynes, the assignment judge of the county in those days, took the appeal on. And the issue in the case dealt with the issuance of process, kind of generally. There was a cross-reference component in the Part 7 rules dealing with the issuance of process, saying look at Part 3 rules on process. And Judge Haynes' opinion, based on exactly what the rule said, would have required that every time a police officer is going to issue process in the form of a summons, that it would be necessary for a neutral and detached judicial officer to make a probable cause determination as to whether or not an offense had been committed and this defendant had committed it. Now, if you stop to think about this, this would have the effect of shutting down the ticket business in New Jersey if police officers had to go before a judicial official every time they wanted to write a careless driving ticket, speeding ticket, parking ticket, whatever it may be. Especially difficult on state troopers who are all over the place and doing multi-jurisdictional type work. So the funny thing about the case was, if you look at the court rules the way they were constituted at that time, Johnny, how you doing, buddy? If you look at the court rules the way they were constituted at that time, Judge Haynes was exactly correct. I mean, that's what it said if you look at the Part 3 rule and cross-reference it to the Part 7 rule. But, of course, that was just kind of a crazy interpretation of it in the sense of the impact that it would have. So right after his opinion was released, the Supreme Court stayed his opinion, recognizing that it would put at least Burlington County out of the ticket business, and directly certified the matter. All right? Now, we get two things that come out of the decision which are of significance for the present-day rules. Number one, the Supreme Court decided substantively that police officers in New Jersey are permitted, if the process they're going to use is a summons, to make their own probable cause determinations. Why? Well, look, generally speaking, when a police officer gets involved with some type of law enforcement activity, he or she doesn't have any personal knowledge of the person he's dealing with. Normally there's no personal vendettas going on. He may have some feelings of anger or something of that nature to the person he's dealing with if he's been provoked. But by and large, police officers are expected to conduct themselves in a professional manner and only issue complaints on summonses when there's probable cause to believe that they do so. In addition, there is kind of safety valves in the system in the sense that if a police officer were to issue process without probable cause, he'd be subject to punishment either through internal type of discipline, or in extreme cases he could actually be subject to prosecution for official misconduct. So these are kind of safety valves that kind of let the Supreme Court believe that police officers, there's nothing brought to the table, so to speak. There's no additional safety brought to the table for the citizenry by having the requirement of an independent probable cause determination made before a police officer issues a summons. Typically in those situations, even if the person's been arrested, he or she's going to be released after going through post-arrest identification procedures on a summons. So the denial of freedom in those few cases where there's going to be a custodial arrest is also very limited. For all these reasons, and the Supreme Court decided that police officers can make their own probable cause determinations, provided that the process they're going to use is a summons. Now, for your purposes, for exam purposes, remember, this only applies to disorderly persons offenses and petty disorderly persons offenses. It also applies to traffic tickets. Indictable matters, things of the fourth degree and higher, are going to require a custodial arrest. They should not be being prepared, on like these small complaints. You can certainly bring people back to the station and release them on summonses, but in terms of just giving them a complaint on the street and sending them on their way, that doesn't happen because people charged with indictable offenses have to go through post-arrest identification procedures. All right? And by the way, you put in your notes, too, that there's two other classes of individuals charged with disorderly persons offenses that have to go through post-arrest identification procedures even though they're being released on summonses, and that would be shoplifters and prostitutes. Those, by statute, and I'll give you the statute in a few moments, they have to go through post-arrest identification procedures. Everybody else could just be released on the street on a summons, either on a traffic ticket or the special form of summons and complaint. You can send them on their way. All right? Now, that's the first substantive holding out of Gonzales. More to the point, though, at the end of the opinion, the Supreme Court suggested that the court rules be revised to eliminate this type of problem in the future, and suggested that it be looked at by both the Criminal Practice Committee as well as the Municipal Court Practice Committee. Well, the Municipal Court Practice Committee took this to heart and did an enormous overhaul study, which took a very, very long time, by the way, and rewrote all the rules. This was primarily done by Judge Robert Switzer of the Hamilton Township Municipal Court in Atlantic County. He's also the judge in Egg Harbor Township, and we really should give him a lot of kudos. He spent a long, long time undertaking the rewrite of all the Part 7 rules. Now, as constituted under the new version of the rules, there are certain style issues that they try to do. Number one, eliminate any type of cross-reference to other parts of the rules. And I think there's only one or two times when there's a cross-reference. But normally, now, all the references to Part 3 rules are taken out with very, very, very few exceptions. That's number one. Number two, plain language. There's a recognition that since there's so many pro se litigants, not only in New Jersey, but around the country, who might have to refer to the Part 7 rules, that in deference to the non-attorneys who would be involved, they try to put the rules in plain language so that lay people could try to understand them. So in that regard, for example, you'll see many of the Latin expressions which we as lawyers are used to seeing all the time have been removed from the court rules.